Okay, I'm unmuted you and made you host. Dan, can you hear me?
Yep.
Okay.
We got Mark Huffman waiting to join.
What do
Yeah.
you see?
I'm gonna admit them whenever we start.
Yeah.
He's already waiting.
Yeah.
All right.
Anxious.
You see the right thing?
I don't see anything right now.
Uh-oh. I've shared my screen.
Not with me.
Yeah, I hit share screen. It's up there. Share. Oh, wait a minute. I didn't hit share. All right, now let me hit share.
There you go.
Now I hit share. Now I hit that.
There we go.
Yep.
There you go.
Try the chat again so we can see if that is gonna come up every time.
All right. Can you see it?
Yeah, let me make you host and see if that changes it.
But I drug it over to my other screen.
I still see it. Here, let me make you host. I don't know how that's gonna work though with Mike.
What if can Mike do the chat?
Yeah, you can just, yeah.
Don't worry about it.
Yeah.
Yeah, and then same thing with Mike, when you start, oh no, Mike's not doing it. Okay, never mind. Yeah, don't worry about the chat then. So is there a way that you can, I'm gonna make you host, just see if that disables it, okay? Okay, I'm changing host to you. Uh-oh, you need to make me co-host real quick.
How do I do that?
Okay, so go out of that. Go to participants,
Where's that at?
bottom. Oh, wait a minute, this may be my screen. Never mind, you don't have to worry. I don't think you have to worry about what I thought you had to worry about.
I had to stop share to get to participants.
Okay, if you will go to see my name,
Mm-hmm.
click on more and make me co-host. Okay, now do that screen share again. Mike, do you see that bar, or is it my bar that I'm seeing?
Well, I don't have the shared screen yet. Hang on a second.
Okay.
Now, Dan, pull up your slide.
Right.
There we go. I still see the toolbar, but I just, like I said before, I just don't think that's worth worrying about.
Do you see though the toolbar that is in Zoom, or do you see the other toolbar?
I see the other toolbar. I come down and get, because I'm a co-host, I come down and manage participants, and I can get chat. But
Okay.
if I don't think somebody who's not a co-host can do that.
I think that's right. Yeah. Okay.
I think we're good.
Okay, we're good. All right, y'all just chill, and then I'll start admitting them whenever y'all are ready.
We got 15 minutes. I'm gonna run to the restroom, do a couple of things before we get started.
I will allow that. Now, Mike.
I'll just leave it up here. So,
Yeah.
Tabitha.
Yes, sir.
So after we get off, talk to Shelley about adjusting our title a little bit to emphasize shared work, and then to figure out how to get everybody who signed up yesterday who couldn't get on, and then a more refined mail out list for Monday.
Okay, yeah, we talked about a couple of those already. So.
Okay, cool. All right, see you in a minute.
Oh, it's not Monday. I think it's Wednesday.
No, we decided on Monday.
Okay, I hadn't gone through all my emails. And Dan, are you going to share me the PowerPoint so I have the right one in case I need to jump in?
I emailed you the link and the document.
Okay, I just need to get off the screen then. Hang on.
Yeah.
Let's see.
So, but Tabitha, what you see the right thing, right?
Yeah, is your email popping up?
What do you mean?
Well,
No.
I see an email that's just like popping up and it's distracting.
I don't see that. I don't see it.
Oh, it's because it's mine. See, I can't tell what's yours and mine.
Yeah.
Okay. Yeah, I see everything now.
Okay, good.
I don't think it'd be a problem.
All right. I'm gonna run get a Coke.
Okay.
I put a do not disturb on my door. Tabitha, are we supposed to go for an hour and a half?
Hour. Yesterday I only went for like 40 though. So I guess it just depends on your content, and they didn't have any questions.
Dan, are you talking about presentation or the whole thing?
The whole thing.
Our whole thing just went as long as people had questions. That's what we told them when we started. Is that we'd answer all the questions we could reasonably.
Uh-huh.
Yeah, I think y'all had so many people though. The one that we did with Win, it went, there wasn't that many questions.
Oh, really?
No,
How many were on that one?
30, I think.
Really?
Yeah. All right. Let's see.
Hope we get more than 3.
Yeah, there wasn't that many signed up.
How many signed up?
I think 30.
Yeah.
I'm glad that stopped.
Yeah. I can't believe how loud that is are you in the office?
Yeah.
Yeah, on the south side, we got a nice echo chamber between our
Yeah.
building and Simmons building.
Mike, what I would do instead of muting it in Zoom, just mute your speaker until you want to talk. That's what I'll do once I give it to you.
Okay, yeah, I'm gonna go ahead and start admitting these people. So if y'all wanna go ahead and mute or whatever y'all need to do now.
Yeah, I
Okay.
did.
Okay. I'm gonna mute myself too.
Good morning, everyone. My name is Dan Herrington. I'll be one of your presenters today. With me is Mike Moore, who you're going to hear from later, and probably a few comments during my talk. This is the Families First Coronavirus Response Act and CARES Act unemployment presentation. Thank you, Cross County Chamber of Commerce and WIN Economic Development Corporation, for asking us to do this, and specific thanks to my board, to your board member and my friend and client John King, and your chamber executive Cody Slater for asking us to do this. If my accent sounds familiar, that's because I'm a proud graduate of Palestine High School and lived in Forest City almost my whole life before going off to college. And so I know this is kind of weird because all you see is the screen and you hear my voice. So I thought I would give you pictures of your speakers today. I won't actually claim to look like Matthew McConaughey, but an attendee once told me at a seminar I sounded like him. And so I took that as a compliment. Another attendee at that same seminar told me I sound like a Baptist preacher, and to both of them I just said, all right, all right, all right. Also have a picture of my partner, Mike Moore, here. Just so you guys can know who you're hearing from today. I'm going to first talk about the Families First Coronavirus Response Act, or the FFCRA as I call it. I'm going to talk about that, and specifically not the entire 800 pages of the act, but the provisions that deal with the two mandated paid leaves, because I'm sure that's why a large part of the reason why you're on here. So the FFCRA was signed into law March 18th, went into effect last Wednesday. It expires December 31, 2020. So this too shall pass. It is enforced by the U.S. Department of Labor Wage Hour Division. The good news is they said they're going to give us kind of an amnesty period to get our posters put up and to comply with the law. There are two basic leaves. So you have the FFCRA, which is the overall act, and within that act, there are two other acts, and that is the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Expansion Act, and I just call that the expanded FMLA or the EFMLA. We're going to talk about emergency paid sick leave first, but just kind of some coverage issues. This applies to any employer under 500, unlike most employment laws that exempt small employers. This one covers everyone from an employer of one employee to 499 and exempts those over. The employee paid sick leave provisions, the 2 weeks of paid leave that we're going to talk about first, apply to any employee no matter how long or how short a duration they've had with you. This includes not-for-profits. It includes public agencies, no matter how many employees they have. So any city or county executives on the line with us, obviously you're covered. There are 6 reasons to get 2 weeks of paid emergency sick leave, and they're on the screen. If the employee is subject to a quarantine order, and that means if the mayor or the governor or some public health official has specifically said to that employee or to a group, for instance, a group coming back from an international trip, and they all, when they come in, they're all told you have to quarantine for 2 weeks. There's going to be a written order or some evidence of that. The second one, if they are advised by their healthcare provider to quarantine due to concerns, that's obviously much broader. Any employee's doctor could say, I recommend that you stay home for 2 weeks, either because you potentially have the condition or you, because of some specific health risk, you're more at risk of a bad outcome. Number 3, an employee is experiencing symptoms and seeking diagnosis. In other words, hey boss, I had a cold, or I mean not a cold, I have a cough and some fever and I'm going to get tested. They get to be off for that. Number 4, if they're caring for an individual subject to an order in number 1, or they're needed to care for a child because of school or daycare is out, or their provider is unavailable due to COVID-19 precautions. And that's going to be, we're going to talk a lot about that one, because I think that's the one that's probably got most clients or most employers worried if you're like the clients that have been calling me for the last 3 weeks. And then finally, number 6, the employee is experiencing substantially similar conditions specified by the Secretaries of Health and Human Services, Treasury, or Labor. And I think what that means is maybe they have SARS, they don't have COVID, so they'd still be protected. So it's paid leave. You have to pay the employee for this leave. Reasons 1 through 3, they get 100% of their wages, but it's capped. So it's a maximum of $511 a day or $5,100 for that 2 weeks. For reasons 4 through 6, the employee gets 2/3 of their regular pay, and that is capped at a maximum of $200 a day or $2,000 total. So the employee, though, on reasons 4 through 6, they could supplement to get back to 100% they could take 1/3 of a day of PTO or vacation if they had any available. So how much do I pay them? Well, it's based on 80 hours for a full-time employee. So even if they work more than 80 hours in a 2-week stretch, because maybe you're on a 12-hour schedule, or that Dow schedule or whatever, or if you're just working a whole bunch of overtime, they don't get the overtime. They just get their flat rate. And if they are a part-time employee, then it's based on their schedule. So let's say in our example, an employee works, earn $12 an hour, and they average, we looked over the last 6 months, and they average 22 hours a week. That would be $264 a week. 2/3 times that is $174. So they don't get 200 just because their total pay would exceed $200. Does the 2/3 pay. So that employee would, in my example, would be entitled to $174. Now, that 2 weeks of leave can be used intermittently. So in the number 5 example, I need to be off to care for the kiddos, and maybe I don't need to be off the entire day to take care of the kiddos, because my kiddos are, say, 12 years old, and I can get them lined out in the morning, and then I can leave them alone for a few hours, maybe not 8 or 9 that it takes to go to work, but I can leave them alone. So if here's the kicker though, if the employee and the employer agree, that leave can be taken intermittently. So keep that in mind, that it is a good way to accommodate your employees, but still get the work done if you're needing to get the work done. So, and that brings us to the next point. The law says that you have to provide this paid leave if the employee is unable to work or unable to telework. So if you have a business and some of that employee's work can be done from home, and you say, look, I'm not going to provide you the paid leave because you can work from home, and here's what I need you to do from home, then they can do that. So what the guidance from the Department of Labor says is you're not required to pay them if you are offering them the ability and the work the work and the ability to do the work from home, unless there are extenuating circumstances. And the Department of Labor gives examples of, the employee is obviously sick. If they are actually experiencing severe symptoms of COVID-19, they can't work from home. That kind of thing. It doesn't give the extenuating circumstance of, look, I've got to help my kids with all this alternative method of instruction for 5 hours a day. I can't do the work while I'm helping my 9-year-old. That's not an example in the regs, but I think it's something, practically speaking, you're going to have to account for, because I'm sure you've already experienced this. We've experienced it in our household with 3 kids in the house and a school teacher mom who's trying to teach 7th grade math via video. That takes more time. And so that's something you're going to have to think about if you have an employee. But this is where you're going to have to just kind of negotiate with your employee who says, look, I need to be home with the kids. But this is sort of a lever, some leverage that you can use, that, hey, I don't have to pay you if you can do some work, and I'm willing to let you work intermittently and to take some time off intermittently over that time period. So what that means, though, is for taking care of the kiddos, this paid sick leave, as we're going to talk about the FMLA expansion, that could last up to 12 weeks. Well, if they're doing it intermittently, it could last even longer, because they get a full allotment of 12 weeks. So let's say you've got them working 4 hours a day. They could actually take that intermittent leave for up to 24. But for Pete's sakes, nobody thinks this is going to last that long. Here's something, and I won't get too far off into the weeds on this, but typically the Department of Labor says if you have an hourly employee, once they start working outside of bona fide meal periods, even if they're not busy, they are still working during that work day. So you know, if you've got an employee and they work 8 to 5 with an hour lunch or what have you, you know, outside of that hour lunch, even if from 2:30 to 3, you don't have any work for them to do, that's paid. Well, that's called the continuous workday rule, but the Department of Labor has suspended that rule to say that you could have an employee, if you can reach an agreement with them to work from home, they can work from like 7:30 to 9, and then 11 to 1, and then 2 to 5 or whatever, and you don't have to pay them for that slack time during the day, even if it's not a bona fide meal period. So just the practical advice is we need to kind of figure out what works for the employee and for the company, and there's going to be a lot of room for negotiation here. So paid leave is the priority. You can't, I've had several clients ask this, well, can't they take their PTO first? I mean, the regular old vacation or sick leave that we provide, and the answer is no, the law is specific on that. And actually had one client ask, well, can I just, we can't afford to give PTO right now. Can I amend my policy to take away other paid sick leaves? The regulations answer that specifically. Now, what they can do, as I said before, if they're getting 2/3 pay for reasons 4 through 6, they can choose to take another third of their PTO just to get back to even. The expanded FMLA, the emergency family, is only for number 6, and that is to care for a child who can't attend school or their day program. So that means even when, we've had this question a lot. Well, what happens? So if school's out, we have to let them stay home to take care of the kids. Well, when school's out on June 1st or whatever day it is, then what? Well, you're going to have to ask that question of your employees. What do you normally do with the kids in the summer? Why can't you do that now? If daycare's closed, then this is still going to apply. Or if they say, well, my mom kept them, but mom is elderly and she's afraid of COVID-19, so she can't take care of them. So that, but hopefully this is going to be over by the time school's out anyway. Now, under the expanded FMLA, to get the additional 10 weeks of leave to care for the kids, assuming they took the first 2 weeks under the Paid Sick Leave Act to take care of the kids, then they have to have worked for you for at least 30 days in the last 60. So there is a minimum employment requirement for this additional leave. So it's 12 weeks total, including any emergency paid sick leave. There's been a lot of confusion. Lots of clients ask me, what does this mean that the first 2 weeks of the expanded family medical leave, the taking care of the kids leave, what does that mean that it's unpaid? Well, the reason it's written that way is because, remember, there are 2 different acts we're talking about. We're talking about the Emergency Paid Sick Leave Act. We're talking about the Expanded Family Medical Leave Act. You get, under the Emergency Paid Sick Leave Act, you can get 2 weeks of leave to take care of the kids. All right. But forget about that act for a minute and just look at the standalone expanded FMLA. You get 12 weeks total of leave to take care of the kiddos. The reason the first 2 weeks are unpaid is because the employee can take leave under the EPSLA and get paid under that law. So that's why, because otherwise there would be a double dip. So that's why it sounds like it's unpaid, but it's really not, because what the law says is the employee can choose to use paid sick leave under the EPSLSA. Well, why wouldn't they? That's just kind of silly, but I've had a lot of people be confused about that. So I wanted to clear that up. So how much do they get paid? Well, again, it's 2/3 the regular rate, same cap. So the example is an employee makes $1,200 a week or $240 a day. Well, then 2/3 times that 240 is $158.40. Again, just a little bit of math, not too much. Now, here's something that I didn't think of until we read the regulations that just came out carefully. What is the employee's rate of pay? Most people, you know, you ask them, what do you make? I make $10 an hour, or I make $15 an hour. Well, you have to look at their weighted average over the last 6 months, or whatever their tenure is if it's less. Now, that shouldn't be that difficult, because it's only relevant if the employee's rate has changed in the last 6 months, right? If they've been making $15 an hour, then they've been making $15 an hour. But if they've gotten a raise, I would say just pay them at their current regular rate. Otherwise, you got to go back and do this reading problem, right? This math problem of what is their weighted average. Now, if they're making less now, then you're going to have to figure that weighted average out, because otherwise you're not paying them all that you should. So there is, if you have 50 or more employees, then you are already subject to the Federal Family Medical Leave Act that provides leave for serious health conditions and pregnancy and childbirth and adoptions and all that. This is merely an expansion of the reasons for Family Medical Leave Act leave. They don't get an additional. So if you actually had an employee who said, look, I need to get this paid sick leave to be off the kiddos, but they had already taken 12 weeks of FMLA leave in the last 12 months, they would not be eligible for any additional leave. So again, what's the interaction between these two leaves, the emergency paid sick leave and the expanded family medical leave, or let's just call it family leave because it's not medical in this instance. If the employee is off to care for their child, then it runs concurrently. But if the employee is off, let's say they've been quarantined for 2 weeks, well, then they would still get an additional 12 weeks under the EFMLA to take care of the kiddos if they needed it. And that's the example, and I won't belabor the example. You can read it there on the slides, what I went through. There is, as in all the employment laws, a non-discrimination component. You may not deny the leave. You may not discipline, discharge, or otherwise discriminate an employee who asks for the leave, takes the leave, is eligible for the leave, or will become eligible. And that will become eligible, I think, was in there either because the employee might not have worked 30 days for you yet, but they will very soon, or obviously the law came out in March, but it was only effective on April 1. Congress and the Department of Labor didn't want people trying to figure out who are our parents that we need to get rid of. So the point is, if you're considering layoffs, you can't try to predict who's going to use the leave or ask for the leave, even though to some extent that would make sense, right? Because if you're laying off some employees and you're not laying off others, and here I think, again, how does this really work in the real world? Well, I think you've got to find out. If you've got employees who are saying, hey, look, I think I'm going to have to go home, well, then you're going to need to take that into account, right? When you're thinking, well, who are we going to lay off? Not that you're going to lay them off because they're taking the leave, but you're going to let them take the leave, and then you're going to keep other people who might have otherwise been laid off. But what if I need to furlough employees? Business is in the tank and I need to lay people off. Are you telling me, Dan, that I have to give employees this paid leave, or if they've already taken it, do I have to let them stay on that paid leave? No, they have no greater rights than if they were actually there today. So if today, April 9th, somebody says, hey, I need to take this leave, either I'm quarantined or one of the 6 reasons, well, then on Friday, April 10th, you decide you're just going to shut the thing down for 2 weeks, 6 weeks, 4 weeks, whatever it is, then they don't get the paid leave. They would be laid off and they would go draw unemployment that Mike is going to talk about here in a couple of minutes. It doesn't prevent layoff, and it certainly doesn't prevent discharge for other legitimate non-discriminatory reasons. So we got to keep documentation. What can we, so the employee says, hey, I need to stay home because of this COVID-19. Well, then you ask for them, what reason, you know, obviously you're going to document name, date, reason. Did we get any written or oral confirmation from their healthcare provider or the mayor or what have you, and a statement that they can't work. I'm not going to read all these to you, but if it's for quarantine, we're going to get a copy of the isolation order. If it's self-quarantine by the doctor, at some point we may not be able to get that quickly because the doctors are so overwhelmed, but we're going to say we're going to need something. And if they're caring for a son or daughter, the law says we can ask the information, who's the kid, what school, and you can request them to provide or require them to provide some evidence that the school is closed. But look, they can send you a screenshot, or they can forward the email from the school or send you a screenshot from the newspaper online, you know, which I don't even know why you would ask, but you will need that to claim your tax credit that we'll talk about at the end of the presentation. There is a small business exemption. So it says for small businesses with fewer than 50 employees, you can take this exemption and you don't have to apply, which you'll see on the next slide. But you can take an exemption if their leave is to care for a kid. You can take this small business exemption, but look at this slide. It's very important, but only if the requirements of this leave jeopardize your business viability. And so I think that's going to be a tough thing to prove, but you don't have to apply. You decide if you meet this exemption and if it would result in expenses and financial obligations exceeding your revenues, if their absence, let's say this employee is just so key that if they leave, we're shut down, but we wouldn't have shut down otherwise, then you can deny that leave. But as we're going to talk about when you hear from Mike, if you try to deny leave under the small business exemption or the healthcare provider exemption that I'll mention momentarily, they're probably just going to leave and take unemployment and probably get more than the 2/3 anyway. So I don't know that the small business exemption or the healthcare provider exemption really are much of an exemption.
Yeah, and you gotta, Dan,
Yeah.
y'all gotta remember that employees, in a lot of occasions are gonna do better on unemployment than they're gonna do on the 2/3 leave. And so you're gonna have a hard time getting them back. I'll talk about that in a little bit.
Yeah. And so there's the small business exemption, the healthcare provider exemption. Now the healthcare provider exemption, with so the statute, remember there's the statute and then there's the regulations. The statute says that the healthcare provider, that word, healthcare provider, those two words, is the same as the FMLA definition, which is really only doctors for our purposes of discussion, doctors and APRNs. But the statute gave the Secretary of Labor the power to expand that definition, arguably, and said that employers could exclude healthcare providers, however they're defined in the law. So the regulation did just that. It expanded healthcare provider to include anybody, the janitor, the biller, the front desk person, anybody who works in a hospital, a doctor's office, a nursing home, who provides home health, who works in a lab, that provides medical testing, that makes medical equipment, compounds drugs. So we're talking about pharmacies, drug manufacturers and compounders, and anyone the governor designates, but the governor hasn't expanded this further. So basically, if you have a business that's a clinic, an eye clinic, a doctor's office, a pharmacy, a nursing home, a home health business, you can just say, we're taking the exemption, and I've had several clinic clients do that. But again, Mike will explain why that's not much of an exemption. Then nobody gets to take the paid leave for any of the reasons, not just the child care reason under reason number 6. So why would you even do this? Well, because you might keep employees at work and you might avoid the cost of paid leave. But as we'll talk about in a minute, you get a tax credit for the cost of it. So it really is going to be 100% reimbursed by the government. And so are you really keeping them at work? Mike's going to tell you, no. What are the risks of taking the exemption? You could get sued, or they could just take the unemployment and they could still sue you. And we don't really have time to get into how that would work, but they could. And you have to remember the statute says healthcare provider means doctor and APRN. Doesn't mean nurse or LPN or CNA or employees who work for the healthcare provider. And so you already have, there was a letter sent to the Secretary of Labor by 2 Democratic members of Congress who said to the Secretary, you're wrong, your regulations go too far, you can't exempt all these people from the provisions of the leave. And so now we have the perfect recipe for lawsuits after all this is over, saying you didn't give them the leave. They were quote unquote forced to go take unemployment. And as Mike will tell you, they could actually get more money and still sue you. Now, what would they get? Because in a lawsuit, you don't get to take credit for unemployment payments that somebody received. You could actually have an employee, you deny them paid leave under one of these exemptions, they go get unemployment, get more money, and then they come back and sue you for the 2/3 pay. And I've been in this business 25 years, and Mike's been in it longer than that. And we can tell you, because you think, why would an employee sue you if they got more money than they would have? Because people sue, right? Nothing surprises me in this business. So really the bottom line is don't do it.
And you can't necessarily subtract the unemployment benefits they got from what they could get in a lawsuit.
Yeah, that's what I'm saying. So
they get to completely double dip.
No good deed goes unpunished, ladies and gentlemen. You could deny the leave, they could get more money, they could still sue you. And they could get, because the enforcement scheme in the FFCRA is the Department of Labor's wage hour enforcement scheme. Mike, they could get 2/3 times 2 plus attorney's fees on top of the sweet unemployment, pandemic unemployment assistance that Mike's going to talk about. So
there's some lawyers around this state who are salivating at the opportunities coming up.
Yeah. So we're not going to beat that to death anymore. So you got to have the poster. If you don't have the poster yet, get it up as soon as possible. DOL.gov. It's right there. You can see there's the website. They're available in Spanish and English. Translation's not required, but if you do have Spanish speakers, get it on your bulletin boards. If you've already got people working from home, email them the form. There is a grace period that we talked about. This won't be enforced, or let me back up. The DOL says they will not enforce the provisions of the FFCRA until April 17th. But as we know from other litigation, you could actually get sued by an employee if you don't get it right. So let's get it right, which, I'm preaching to the choir because you're on this webinar with us. Here's the good news though, right? 100% tax credits on the payments made in the FFCRA. And when this first came out or was first announced, what we were worried about, and I'm sure you were worried about, was this is not going to, if I have to file for this on my tax return next April, that's not going to do me any good. Well, here's the good news. Let's just say you have $10,000 of payments that you've now made under the FFCRA. But then next quarter, you've got $10,000 worth of payroll tax remittances that you need to make with your quarterly filing. The IRS says, and the DOL, they say, just hang on to that 10,000, keep it in your account. Don't send it to us. You just keep it and use it. And then we'll square up at the end of the year. And, you know, you could be audited, of course. You need to keep the records to prove that you paid this money in accordance with the FFCRA. And that's what the next couple of slides are about. What information?
Hey, Dan, let me interrupt just a second.
Yeah,
I put this in chat, and I'm not sure y'all are seeing it, so I wanted to say it out loud. If you've got a question about any of this, type it in the chat, either to me or to Dan, or preferably to everyone, and so we can, when we get done with the presentation, we want to be able to answer all your questions. And if you'll put them in the chat box, then we can see that and start answering the questions as soon as we get done with the actual presentation.
Great. So here's the information for the tax credits. You need that information so you can say, if the IRS asks, and these last two slides come directly from the IRS, and the guidance, the Department of Labor regulations say you've got to keep it, you got to keep this information for 4 years. So that's pretty, that makes sense. All right. So we're going to jump right into the CARES Act, and Mike's going to take it from here unless I've got something snarky to say. So go ahead, Mike.
Thanks, Dan. Glad to be with you all today to kind of go over all of the recent changes. About 3 weeks ago, I was on the phone with the director of unemployment for the state, and she said, we just had to change the entire way we did unemployment in 72 hours. And she said that before they passed the CARES Act. And so now we have, we're in the process of completely upsetting the apple cart. It is an amazing transformation to what unemployment is going to look like for the next little while. The CARES Act was signed by the president on March 27th. It is Coronavirus Aid, Relief, and Economic Security Act. It will also be in place until, most of it will be in place until the end of the year. It provides for 3 different kinds of unemployment compensation, which are in addition to regular UI or EB benefits under state and federal law. They are PUA, Pandemic Unemployment Assistance, PUEC, Pandemic Emergency Unemployment Compensation, and FPUC, Federal Pandemic Unemployment Compensation. And we got a lot of letters floating around today, and so we'll try and define them enough where you won't have to remember all the letters. So PUA is the first part of the CARES Act, and it is provided for in section 2102 of that act, and it provides for unemployment assistance for people who are not eligible for regular unemployment under state regular UI benefits. That is anybody who is unable to claim benefits because they're out of their unemployment benefits, they have been disqualified from benefits, they have not enough employment history to qualify for unemployment benefits. It specifically includes independent contractors, gig workers, self-employed, solo proprietorships. I think I talk about it in the it's the hairdresser, massage therapist, tattoo artist provision, but importantly also extends to employees who, for example, were disqualified from benefits because they were discharged for misconduct in connection with their last work. I believe it will also be applied to somebody who's been disqualified for benefits because they engaged in fraudulent claims in the past. So it is meant to cover anybody who can't get regular unemployment. All right, PUA, Pandemic UI Assistance, it is available backdated to January 27th, goes to the end of the year, but provides only up to 39 weeks of benefits. PEUC provides an extra 13 week of benefits where people have exhausted their regular state unemployment benefits, which in Arkansas are 16 weeks at this point. My information from talking to the people at the state is that our unemployment numbers will probably kick all the triggers in to trigger the extended benefit period. So the FPUC is the other, and it is the one that most of the people are talking about. It is the one the senators, before the House passed it and the president signed it, were squawking about. That was an unintended consequence. And that's $600 to anybody drawing any kind of unemployment. Anybody drawing any kind of unemployment. And that ends currently, it is scheduled to end July 31st. Obviously, if things stay bad, it will probably be extended. So that FPUC is maybe paid on top of any weekly unemployment benefits. We had a question yesterday from a client where he said he had heard that states were reducing their benefits or trying to offset them against this 600, and that is not the case. The law specifically prohibits a state from reducing their benefits in response to this. Goes through the week ending July 25th. Again, most must be eligible for either regular or PUA, and since those are mutually exclusive, it's anybody entitled to any kind of unemployment. All right, the good news, well, a couple of other things, is the FPUC provides for and requires the state to waive the first week waiting period, which has historically been in place. The good news is the feds are funding that benefit. So all of the employees who are losing their job and get unemployment get it beginning the first week of their unemployment. It also provides for financing for programs such as the shared work program, which I'm going to talk about in a little bit. It authorizes the use of those programs for up to 26 weeks. Arkansas is one of the 28 states that participate in these shared work programs. So the CARES Act programs, the benefits to those not eligible for state benefits, the extra 13 and the extra 600, the good news is that those are all federally funded. And so if somebody is getting those benefits, those are not taken from the unemployment trust fund, which currently stands at about $850 million. Y'all were all paying in high taxes over the last decade to that trust fund, trying to get it back up where it would survive a recession, so we wouldn't hit what happened after the last recession. And as I'm sure most of y'all have figured out, the last couple of years, your unemployment taxes have gone down greatly over the last few years. All right, so if the state runs out of unemployment trust fund benefits, they'll have to borrow from the feds again, and that's gonna really hit your pocketbook. so that the state has the incentive to classify anybody who's on unemployment as PUA and not regular. The other thing that the CARES Act does for nonprofits who are reimbursing employers is that it provides great flexibility for the state so that those employers do not have to reimburse the trust fund for the payments made on their behalf. What we found out in the last couple of days is that the feds are actually going to are going to cover half of those costs for reimbursing employers. And so far, the state has said that they're going to delay the reimbursement time until March of 2021 is what our information is currently. All right, so the big difference, one of the big differences in PUA and regular UI is that it appears that the state is going to make the determination as to eligibility on the front end based solely upon what the applicant says. That then there will be a notice to the last employer, and I assume base employer, and the last employer will then have an opportunity to appeal the determination, but there will be an agency determination already in place. So those are eligible if they self-certify that they're able to work, available to work, and unemployed or partially unemployed, or that they're unable to work for a covered reason. Those covered reasons are similar to those in what I call FFRCA, which was what Dan was talking about a few minutes ago. Diagnosed with COVID-19, experienced symptoms and seeking medical attention, member of the household diagnosed, individual is caring for a diagnosed family member. They have primary caregiving responsibility for the child, unable to attend school.
That kind of sounds familiar, doesn't it, guys?
Same basic reasons. Unable to reach their job because of a quarantine imposed or self-quarantine direction, and they were scheduled to commence their job, but they can't get there because of that. But they became a breadwinner because a family member has died from the disease. They quit as a direct result, or their place of an employment has been closed as a direct result of COVID-19. I want to stop a little bit and talk about the quit as a direct result, and tell y'all as an aside, I had a conversation with somebody at DWS last week about that, and they said that if somebody says to them, I was scared I was going to get sick if I went to work, so I quit, that's going to be enough to get unemployment based on that self-certification. My belief, however, is that if an employer appeals that with a statement such as, they expressed to us they were scared of getting sick, and we engaged them in an interactive process, to use terms from another act, about how we could accommodate that fear to make them less susceptible to infection, but they refused to accept that. I believe that you would have a chance at having them disqualified, just as if in a regular quit situation, an employee fails to take reasonable measures to protect their job rights. I think it's easy as an employer to chin that bar. And most of the people who are going to say, I want to quit because I'm scared, it doesn't much matter what you say, they're going to quit anyway. The other thing, There is also an employee retention tax credit available to private employers and nonprofits where you get a refundable payroll tax credit for 50% of the wages that you pay. And it's available to employers whose operations are fully or partially suspended due to a shutdown order or their gross receipts decline by more than 50% compared to the same quarter last year. If, however, you're getting a PPP loan, you can't take advantage of this. I'd be interested to people saying, telling us in chat whether they're taking advantage or trying to take advantage of the PPP loans. There's also the delay of payroll tax, where you can defer half to the close of business of 2021 and half to close of business 2022. But again, if you're getting a PPP loan, you're not going to be able to do that. If you've had it forgiven, obviously you can get the PPP loan and pay it out, and then still take advantage of this payroll tax deferment. Next couple slides are from the Department of Workforce Services on methods to apply for unemployment benefits. I think it's a great thing. I believe you can go on and they have a nice poster that you can post, because it's going to be an interesting process for y'all, and it will be easier to point an employee that's going out the door to that poster, and in the first instance, rather than having to sit down and talk with all of those employees. So we have online, telephone, and either paper, either in person or by mail. Next couple of slides, Dan. Well, there's the phone hotline, and then the paper. I was on I was watching the governor's press conference yesterday, and Mike Preston was discussing the efforts they're making to update their system. And what we have to understand is, for the PUA benefits, the state has to develop an entirely new application for unemployment form, which gives an individual an opportunity to describe the reasons for their unemployment, so that the state can decide, are they eligible for any benefits? Are they eligible for PUA, or are they eligible for regular UI? And Mike said that it's going to be about 3 more weeks before they can get that form in place to effectively handle claims. And so he was begging people to wait to apply. Obviously, people are not going to pay attention to that, but you can tell your folks that especially that are needing to apply for PUA, they might as well wait. Because one of the things that the state has to do in order to grant PUA, they have to first determine that somebody is not entitled to regular unemployment benefits. All right, so we don't have a waiting period. Claims that are otherwise eligible, and that is for UI, can expect payment of benefits in the following week. My understanding is that checks began to go out Monday. And some of those checks included a payment of $390, which I believe was a partial week of the $600. So partial unemployment is also available under PUA, and the calculation of benefits for PUA for partial unemployment would be made in the same manner as calculation of benefits for full unemployment. When individuals are collecting partial unemployment benefits, they have to report their earnings when filing their weekly claim. They can earn up to 140% of the weekly benefit amount before there is a dollar for dollar reduction in the amount of benefits they receive. My head starts to spin when I try and figure out how the partial unemployment weekly benefit amount weekly earnings calculation goes. And so there is there's a pretty a pretty good table on the unemployment website where you can do that. The table here on this slide gives a real generalized view of that.
Hey, Mike, where can we get that chart?
Well, everybody that's on this is going to get the chart that's on this slide. The other chart, and I don't have the actual page, but it's on the DWS website.
Okay.
So
how does the 140% disqualification and the shared work, how does that relate to the federal unemployment assistance under the CARES Act?
okay, so let's move to the next slide. We have some slides. Hang on just a second, Dan. Tabitha was trying to upload slides on the shared work program.
I've got them ready. Whenever you are, I'll take over.
Yeah, please, if you'll run that real quick, let me
I'm
run.
going to stop share.
Don't do that. I think I should just be able to take over. Just 1 second. Let me get it all pulled up, please. Let's see if this will work. Can you see my work shared screen?
Yes.
Yeah.
Okay.
Yeah.
Okay, just tell me when.
Thank you. Yeah, let's go ahead. Let me start by telling y'all that the shared work program we're gonna really promote, and I'm really promoting that because the state's really promoting it, and the state's really promoting it because shared work program is 100% federally funded. We talked about it a little while ago, and partial unemployment under the state UI system is not. And so there are a whole bunch of benefits for y'all directly and indirectly to be putting people on a shared work program. There were some questions I got yesterday about whether it wouldn't be better to lay some people off and have some people work full time. And that's not a good idea because the people laid off are going to get regular UI benefits, and that's going to get charged against your experience rating and going to come out of the employment trust fund, the unemployment trust fund. And based upon the benefits most of your employees would get if they're completely laid off, they're not going to want to come back to work. And the other conversation I had with people at DWS were that people who are receiving unemployment benefits that are higher than what they would make, if they say that I'm not going to come back to my job because I'm making more, they'll probably not be disqualified. A crazy result, but that's a difficult pill we got to swallow. So a share work program is administered by DWS and has to be approved by DWS. It allows you to reduce the hours of your or a group of your employees by up to 40%. It has to be at least 10%, but up to 40%. The employees get a portion of their unemployment benefits while working those reduced hours. You can run that program for up to 25 weeks. And you can use that program for any group of employees you want to. All right, let's move on, Dan. All right, so as I said, it's good for y'all because your ratings are not affected, and they get partial wages, partial unemployment, plus $600 in a weekly benefit. So they're really going to make out pretty well. 10 to 40%, they would be otherwise eligible to receive regular unemployment. They're able to and available to work those reduced hours. You can't have laid off more than 10% of the employees in that group within the last 4 months. So if you've already laid off a group, it's going to be a difficult time. You can't really bring them back and put them under a work share program, but you can put any of the employees that remain under the work share program. And that quote unquote affected group is basically whichever group of employees you put in your application. And you have to certify that if you didn't have the program, you'd have to lay off at least 10% of the employees you have in that group. The DWS is recommending for people who want to do this to go ahead and do the program at a 40% reduction. And you have to include the name, social security number, normal weekly hours, and proposed percent reduction. And then you have to include the estimate of the number of layoffs that would occur absent. And so you'd put the same percentage as you put your proposed reduction. The reason they're saying proposed 40% is that they can always adjust the employee's weekly benefit to be less if, for example, they worked 75%. Because remember, you have to report the weekly wages, and so their benefit may change week to week. All right, let's go ahead. It may take up to 30 days. We have gotten significantly faster turnaround times, like 3 days, and have been in regular contact with the guy at DWS who runs these programs. And so we were able to get in and seem to be getting some good response from them. I will say that in my experience, the people at DWS are very helpful. Every time I've had a question, they're willing to answer it. The one thing that we're hearing from this guy is there's a lot of manual input that they have to do. And so to make sure that we get rid of typos in the forms and don't hurry through them, to make sure everything is answered properly so that they can run it through on the first go through. All right. So can I use the program if I got a PPP loan? Yes, you can, but you have to make sure that that you are spending 75% of that loan proceeds on payroll. There are some ways you can shave the numbers pretty closely, but that's what you have to be careful of. Does the program apply to exempt employees? Yes, it does. You can include exempt employees in your affected group. You have to be careful because you may be cutting their salary below the threshold for exemption. Shouldn't be a problem because if you're cutting them below the salary threshold, you're probably cutting their hours enough. They're not working 40 anyway. The fact that they may lose the exemption during the shared work program will not adversely affect their exemption at the conclusion of that. All right, so we have a few questions. All right, so let me read the two questions that I can see. We have an employee that wanted to do voluntary quarantine, no exposure, medical mandatory quarantine reasons, that doesn't want to return until COVID is over. Our business is open, her position is being filled by another employee. We gave her a notice of separation. She wants to file for unemployment. What's the correct solution for a situation like this for a person who doesn't qualify for the leave? That she's probably going to get her unemployment because she'll self-certify that she was forced to quit for a COVID-related reason. She's going to have to wait until they get that form in order to do that. But y'all can respond and object to that claim, saying that.
Hey, Mike, let me interject. Brittany, what we don't know from your question is, does this employee have some, are they just scared? And that's what Mike said. They're going to get unemployment, but I think you also need to think about whether that employee, they have some underlying health condition that might qualify as a disability under the Americans with Disabilities Act, even if a doctor did not tell them you need to self-quarantine. If they were asking for an accommodation of sorts of unpaid leave, then terminating them and not bringing them back presents some risk. But if they don't have anything that would be a disability, then you don't have anything to worry about. Brittany responds, I guess everybody can see this. We set up an online office and offered to let her work from home. That's where I think Mike says, initially she's going to get unemployment, but when you get the opportunity to respond, and you need to make sure DWS knows that, because you don't get the paid leave if you're offered telework and can do it. And B, I don't think you get unemployment if you're able to telework, right, Mike?
Correct. You're then resigning, not directly related to COVID.
Yeah, there was another question before that one, Mike. I don't know if you can see it. It says, what do we do if an employee turns in a medical form for a spouse that suggests a 7-day quarantine, but it doesn't say the quarantine's because of COVID-19 reasons? I think, Sarah, you just need to clarify that with the doctor's office, because I can't think of another reason right now why someone would be quarantined. So that's just, I think you give them the paid leave. What you want to do is make sure that you get clarification that it was for some concern, not signs or symptoms, but it can be because of a concern, COVID-19 concern. And then you'll need that if you're ever audited on the payroll tax credit. Mike, I'm going to let you answer the one about a self-employed person who operated a salon but was denied because they had a net operating loss in the during the period, I guess, preceding that, because that may be something that we have to answer.
Yeah.
Later.
So, haven't seen a lot of tax returns for self-employed people and defending lawsuits. It seems like a whole lot of self-employed people end up with a net operating loss, and so I suspect that. Well, let me back up a second, because they hadn't necessarily been denied because of that, because this process, the PUA process, is not even in place. But what the DOL and DWS have to do is determine the method of determining what would be the equivalent of wages for a self-employed person. And as they do that, that will shake out. And my guess is they will come up with something that's a reasonably fair way to determine what their gross receipts would be, and whether that would approximate what wages would be.
Mike, another question was, did any of these programs affect the amount of unemployment tax we are to pay? And as I understand it, to the extent that employees are receiving regular unemployment, it's going, and the trust funds depleted, at some point, we're going to have to, as employers, our unemployment contributions are going to address that. But all the CARES Act unemployment that Mike's talked about today, that will not, that's not going to impact your experience rating or your taxes, right, Mike?
Yeah. So what will happen is if your employees are all that are off, or all either are receiving some CARES Act benefit, it won't impact your experience rating. However, because there will be a lot of people who are receiving regular unemployment benefits, not PUA benefits and not FPUC benefits, but just regular UI benefits, it is going to deplete the trust fund some. That is going to kick in. Number one is going to kick in a raise in the taxable wage base from what is now 7 back to 10 or possibly $12,000. It is going to kick in some of the incremental taxes that are provided for under the law, and depending on how much the trust fund is depleted, it could kick in some other unemployment taxes, but it should not change your experience rating, except to the extent that you have former employees who are receiving regular UI benefits. I don't see any other questions.
So Esther, if you will email me or Mike, we'll, if you have any additional questions about that. All right, well, we'll give it a few more minutes, or a couple more minutes for questions. We want to make sure you have an opportunity to ask anything you want. We again appreciate the Cross County Chamber of Commerce and the Wynn Economic Development Corporation for asking us to do this and providing this to you members, and we're happy to do it. And so whatever you've got for us, just let us know. Okay, looks like we got another. Under the leave programs, are we to pay the employee and then be reimbursed? Yes. So the 2 leave programs, you know, we're going to be either paying 100% with the cap at $511 a day, or paying 2/3 capped at $200 a day. That's money we'll have to pay, and it won't be a reimbursement per se. Again, you'll get to take on your quarterly tax filings and remittances to the IRS for your payroll taxes. If you, again, simple example, if you've paid out $10,000 in FFCRA leave payments, and you've got $10,000 in money that you need to send the government for your payroll taxes, you'll just hang on to that. You'll get to keep that. So it's you know, of course, it works the same. Let's say, so you could do that over as many quarters as you need to do to make up for what you've paid in those FFCRA payments. So nobody is applying for the SBA loans or has applied? Okay, if you're, so then a follow-up to that question was, and if we don't allow unemployment, can we be sued? Well, you don't get to decide whether they get unemployment. What you would be sued for is if you denied either the emergency paid sick leave or the emergency family leave. If you said we're taking the small business exemption, or you don't qualify, what could happen is the employee who you deny the paid leave to, they go get unemployment, and then they sue you. They go get a private attorney and they sue you. And in general litigation, you don't get to take credit for unemployment that an employee receives. So that means that if you had a particularly, I'll just say it, particularly greedy employee, they go get on it, and let's say you brought them back after this is all over. So they don't have a permanent job loss. They just got unemployment for the let's just say 8 weeks of leave they needed to take care of the kids. You could actually be sued, and they could wind up with a windfall. So just make sure that you go back and review the FFCRA information to make sure that if they're entitled to the leave, you get it. A new question: we've submitted the PPP application. Should we retract it so we qualify for some of the other programs? I don't think so. I mean, we've studied that. That's not the presentation today, but I don't see the tax credits under the FFCRA or the tax credits that you would get for paying payroll if you lost. You lost 50% of your business. I don't see them making up what you can use the proceeds for the PPP loan. Because remember, if you get that PPP loan, you can use up to 25% of it for rent and utilities and those types of business expenses, and still get 100% forgiveness. So keep that in mind. I will say you can't use, if you're doing the 2/3 payments for somebody off on leave, that's not wages. So as I understand it, Mike, correct me if I'm wrong, I don't think you can use your PPP money to pay that, but that's okay because you're going to get the payroll tax credit for that. So
so the balancing act is, if you have a significant number of your employees out on the 2/3 emergency family medical leave, since you can't use that payment as payroll, you can't count that towards your 75% payroll requirement for PPP loan forgiveness. So some people who are trying to hit both of those are paying the extra third in wages in order to help them get over that 75% payroll threshold. And that's for everybody, for every business, that's just going to be you just got to sit down with pencil and paper and figure out where each side of that falls.
Okay, so if you're typing a long one, send us a chat that says typing. Otherwise, in about 30 seconds, we're going to be done. Again, we thank you for participating. We thank you for your great questions. Okay, Tabitha, if you want to end us again, you guys have a great day.
Thank you.